before I go on to that, we have to make our declarations of interest, so we will do that beginning with Sir Ashley Fox.
Good afternoon, Ashley Fox, member for Bridgewater. My interests are as declared.
Good afternoon, Neil Shastri-Hurst, member for Solihull West and Shirley. In addition to my interests as declared on the register, I'm a practising barrister who holds a current practising certificate with Bar Council, and I'm an associate tenant of number 5 Chambers.
Good afternoon, I'm Warren Digges. I'm Member of Parliament in Wolverhampton West. I'm a solicitor but not practising. I'm a member of the GMB Trade Union Executive Council and various APPGs.
Alex Swart, I'm the MP for Hammersmith, chair of the committee. I'm a non-practising barrister. I'm a member of the GMB and Unite Trade Unions and the patron of 2 justice-related charities, the Upper Room and Hammersmith Fulham Law Centre.
Sarah Russell, solicitor specialising in employment law. Prior to arriving here, I'm on various APPGs, as you would imagine, and a member of various trade unions. I chair the Access, or co-chair the Access to Justice APPG.
Good afternoon, Pam Cox. I'm the Member of Parliament for Colchester. My interests are as declared on the register. I chair the APPG Penal Affairs.
Good afternoon, Vicky Slade, MP for Mid Dorset and North Poole. Interests as declared, but none relevant, just as a person who's been involved with the system on the right side. Just clarify.
I'm Tessa Munt. I'm the member for Wells and Mendip Hills in Somerset. All my interests are declared on the register, but I also want to point out I'm Vice Chair and a Director of Whistleblowers UK, which is a non-profit making organisation, and I'm Vice Chair to Pam's APPG on Penal Affairs, amongst other things. Those are the most relevant. Thank you.
I'm Tony Vaughan, the MP for Folkestone and Hythe. I'm a practising barrister, also with a valid practising certificate. I'm an associate tenant at Doughty Street Chambers, and I draw attention to my register of interests.
Thank you very much. So, Lord Chancellor, over to you.
Well, thank you very much, and this is my first opportunity to appear before the Select Committee, and I thank the Select Committee for its work to date, and I did take the opportunity to look at the video of the previous Lord Chancellor just a year ago. The committee will know that I'm not new to the justice issues. I was under Charlie Faulkner, responsible for legal aid in the old Department for Constitutional Affairs. I led the Lammy review, which was commissioned by David Cameron and Michael Gove at the time into disproportionality. I shadowed this brief, and it's a great privilege to be in this brief at this time. You will know from testimony in your own inquiries over the last 18 months or so that the government inherited 2 crises effectively. One was a prisons crisis, a capacity crisis, in which we had to act, and indeed now we have the sentencing bill going through, which will substantially alleviate that crisis. And then, of course, we've got the backlog crisis in our courts. I sometimes think we should describe that as a waiting list crisis, really, so the public can fully understand those who aren't in the criminal justice system. And I suspect some of your questions will pertain to the courts bill, which will come forward next year to deal with that crisis. But I'm very pleased that we've been able to put more money into legal aid, particularly for criminal barristers, for solicitors, for immigration, for housing, that we are also investing in our prison system. There is a lot to do. This is an area that really suffered hugely during the years of austerity. Not everyone sees inside a prison, but our prisons, as you will know, are in a dire state. We need to invest in staff, we need to invest in technology. There is much to do, but it's important in investing that 4.7 billion that we deliver those 14,000 prison places by 2031 to alleviate pressure, of course, in the estate as the sentencing bill comes into act, that we also continue to deal with foreign national offenders, which is a subject that the public care a lot about, and that over the course of this next period that we uplift probation particularly, and the 700 million in the spending review going into probation to get probation back to where it should be is essential, and that's why I made probation my first visit as Lord Chancellor particularly. I look forward to your questions, but the theme that I keep returning to is telling a bigger story about justice. Justice is not just about criminal justice. We also have our civil courts, 47 billion contribution from legal services to GDP in this country, which is hugely important in terms of growth, and to ensure that the system is modernised over this next decade, digital being at the heart of that, in the prison service, absolutely in our courts, and right across the system to alleviate some of the pressures that our probation officers are facing at this time.
Thank you very much. And the committee takes your point, and we do a lot of work on civil, family and other forms of justice. But a lot of the questions, we will be touching on those this afternoon, a lot of the questions this afternoon will be around criminal justice, in particular the part one of the Leveson review and the government's response to that on releases of prisoners and on probation service, which you mentioned. I should perhaps also add that we wrote to you and you kindly replied onto a number of detailed questions in relation to the matters concerning jury trials and related matters from Leveson, and that has just been published online. It answers some of our questions, but thankfully for the benefit this afternoon, not all of them. So I'm going to begin by asking a few questions on Leveson, and then my colleagues will come in as they wish. The first point that occurred to us is, has there been a formal response to Leveson? Now that's a very substantial piece of work, 388 pages. And we know obviously some of the things the government has said that it either adopts or goes further than or doesn't comment on. But is there going to be a formal response? And the second part of that question would be, you mentioned legislations and a court's bill. What needs to go into that bill, and when do we expect to see that bill?
There will be a formal response in the spring. It's my intention to come forward with a courts bill and legislation also in the spring. And I know that this committee is also focused on the modelling that sits behind where we have come to. And of course, I want to assure the committee that there will be the proper scrutiny when we do get to publishing a bill in terms of the impact assessment, both economic and equalities, that understandably parliamentarians will want to scrutinise and understand. So I have those three things to do. Alongside that, I know this committee will understand that I will be settling the Concordat with the Lady Chief Justice, which effectively also is pertinent to some of that modelling and to, as we draft legislation and both invest and reform at the same time.
Yes, we've had Leveson for some months now. We're talking about a response and a bill in the spring. I don't know if you can be any more specific than that, because there's clearly, to make some of the suggestions that you have to changes in mode of trial, powers of magistrates, judges sitting alone, you must have done some number crunching, you must have that information available. Why can't you publish that now?
Some of those numbers will actually relate to where we come out in the Concordat process, both in terms of investment in sitting days and where we end up, and therefore I'm not able to publish the modelling now. The modelling is an ongoing process, as you would expect. I indicated the landing spot in my statement a couple of weeks ago to indicate where the government was. We will be coming forward with a bill, and the detailed work is going on as we speak, and some of that detailed work of course involves work with the judiciary.
You know when part 2 of Leveson is going to be published? Will your response deal with that as well, and will the legislation deal with that as well?
Sir Brian has indicated that he expects to produce his response also in the spring, so the spring will be very busy. Part of the reason why it was determined to have, if you like, part one, which is the reform which will require legislation, and part two, which is really about processes and efficiency, which is unlikely to require legislation, is that we could get on with both, if you like, at the same time. But we will obviously, we are very much in the hands of Parliament once we introduce the bill and how long it takes to pass through the House. So I don't anticipate that Leveson 2 will require legislation. I think it will be processes that we can get on with, and we will need to consider that carefully. So I'm not anticipating a response immediately to Leveson Part 2.
Where do we look now? Spring, we know, is a movable feast, a movable season in political terms. Where do we go now to find out exactly what the government is proposing to do? Because it's a subject of great interest to the public and to politicians now, and we're sort of reliant on individual statements and answers to questions and things of that nature. That doesn't seem satisfactory for something as substantial as this.
Well, look, I recognise the need for this committee to be able to scrutinise, and I will reflect on how I can support the committee in that scrutiny. And it may be that there's a pre-legislative way in which the committee can get on with its important work. I know that the Chair will recognise that it's not unusual for government to make a statement, and indeed if we come forward with legislation in the spring, that will be still in this session of Parliament and pretty early for the government to come forward with that legislation. And that legislation will, as I've said, have the impact statements, and that will be subject to a lot of scrutiny, including by this committee.
And do you expect the bill to become law, presumably not in this session of Parliament, in the next session, before the end of the year? When will the measures in the bill take effect?
Well, it's my hope that the bill gets royal assent by the end of next year. That is, of course, my hope, and that is why I want to bring forward the bill in the spring, because that's how we get the maximum benefit of those reforms. Effectively, the backlog will continue to go up, even if we're getting on with implementing Part 2 of Sir Brian Leveson's work, even notwithstanding the fact, and we'll talk further about this no doubt, that I want to continue to invest in sitting days. So it's not until we get this legislation, in fact, that we'll be able to be doing all three of those things: investment, reform and modernisation.
You're talking about substantial changes to mode of trial, restriction of jury trial, substantial increase in magistrate sentencing powers, judges sitting alone, not even with magistrates alongside them. Would you be making any or all of those changes were it not for the backlog?
I think that's a very good question. Modernisation is required anyway. Let's put the backlog to one side, because when we look at the trends, they are worrying. We've got tribal either way offences in the magistrates' court taking longer. We've got trials taking longer. We've got police arresting more, up 10%. Colleagues who are very experienced around this room recognise big innovations in policing and in investigations, DNA evidence, phenotype evidence within that DNA evidence, CCTV, the complexity of data and systems, all of that leading to lengthy trials. And so I do believe that the time has come to modernise a criminal court system that has effectively not been modernised since 1971. and that was the year before I was born. And so, yes, we do have to deal with the backlog. And it's 78,000 now. It will be over 100,000 by 2028-29 if we did nothing, and heading in the wrong direction. But frankly, because of what's happening, and indeed this place is legislating more, historic crimes are driving arrests. There's complexity with some of the sexual offences that this House has put onto the statute book. All of that requires, I believe, some reform to the criminal justice system.
So you see, I think it was almost a yes or no question.
Sorry.
And it's the answer.
I wanted to give you this.
It's the answer, yes, even if the backlog was at a sustainable level, that you will still be looking to make some of these changes, restrictions to jury trials, not allowing a rehearing from a magistrate's decision. There's significant changes in the way the system is operated, which are restricting in terms of the way the criminal justice system operates. And you're saying you would be going ahead with those in any event?
Yes.
There are several ways in which you can tackle the backlog. We can become more efficient, you can put more money in, or you can make the changes that you're proposing. Now, I don't know whether those are all worked out, but in the letter you sent to me last night, you say the open case log will be over 116,000 cases in our central scenario by June 2029 without taking further action, and over 125,000 cases in our high scenario compared to around 78,000 currently. I'm assuming it doesn't say so in terms that is if you do nothing.
That's right.
If you do nothing, those are the sort of levels that it will rise to over that period of time. Now, clearly you could have pushed ahead with what additional resources you can put in, sitting days, for example, repairing courts so that more courts can be used. You could make the system more efficient. You could make prison transport more efficient so that there weren't so many delays in dealing with prisoners in custody. Before you had to make these controversial, substantial and difficult, requiring legislative change. So why didn't you take that approach?
Well, I recognise the question, and we do have to do it. Sir Brian concluded, and I accept his judgment and his conclusions, that yes, efficiencies were important, but they would not be sufficient. And let's just step back and understand why they would not be sufficient. One is...
So I'm sorry to interrupt you, but I think what we're looking for is figures. So to know what the backlog would be if you just did the mode of trial and other changes, what would the backlog be before you put any efficiency measures or extra funding in? Can you break down how that backlog divides amongst those various cures?
I don't think it's not as straightforward as that. One, because we must let Brian do his work. But let me just come back to what we're really saying. Running a Crown Court trial is a bit like running an operation in a big hospital. It requires more than just the judge and the jury. It requires barristers, and we have, as you know, got a real problem with the pipeline of criminal barristers, and that's why I made the announcement that I made. It will take time for those barristers to come on stream. It requires courtrooms, and this committee has taken an interest in real maintenance issues. We have found extra money, but again, restoring our courts to where they were, given that they were languishing for 14 years, will also take time. Victims can't wait and shouldn't have to wait. And that's why Brian concluded that, yes, we must deal with those efficiencies, but we also have to act. And when we look at the cases vacated, when we look at the cases that are effectively unable to go forward, a part of those are related to efficiency, but some of those are also related to how the process is working between the magistrates and the Crown Court. And so the judgment that Sir Brian takes, and I accept that he's right in this, was could our magistrates do more? should we still have the right to elect, and there are decisions that we've made in terms of mode of trial, and effectively of the 3% of Crown Court cases that go forward towards the bottom end of that, between the magistrates and up to 3 years, are we content for a shoplifting case or for a driving without insurance? Are we content for a case like that to be before a single judge? And that is the balance of judgment that I have taken.
I'm going to pause there because I know a number of colleagues want to come in, so I'll start with Neil.
Thank you very much, Chair. Lord Chancellor, I'd like to come back to the issue of the evidence base for curtailing jury trials. Are you able to confirm whether the government currently holds empirical data demonstrating that restricting the right to trial by jury will materially reduce the backlog?
Yes, of course we do.
Okay. If that data exists, will you not only publish it but ensure that it includes all the assumptions associated with it, all the modelling and all the sensitivity analysis?
As you know, ministers have a range of data available to them. That data is being updated, it's being validated. Sir Brian himself relied on some of that data, which will inform our data. And as I've said, we will publish the impact assessments alongside the bill. And I will seek to help the committee as it seeks to scrutinise that as we get to that stage in the spring.
At the risk of repeating the question, you've said you'll publish the impact assessment, but will you include within that all of the assumptions, all of the modelling and all the sensitivity analysis?
I will include, of course, the assumptions that sit behind where we've got that enables Parliament to properly scrutinise and helps people understand why the government has arrived at the position it has.
Noticed you're reluctant to use the word all. Will you produce all the analysis?
I will do what I deem appropriate for the purposes of this bill passing and to ensure parliamentary scrutiny. I've been in Parliament 25 years. I've seen a number of impact assessments, both economic and equalities. Equalities is particularly important in this area, as is the economic data that we believe will drive down the figures, and of course that will be available to the committee.
You will be aware that both the Bar Council and the Criminal Bar Association have concerns about this specific proposal. They have requested the data. Is there a reason that data has not been shared with them at this stage, given that they are such critical stakeholders?
Well, we will continue to work with the Bar Council in the usual way, as you would expect.
Do you accept their position, which is that Sir Brian, whilst it's a worthy piece of work, his recommendations have neither been piloted nor have they been modelled thoroughly? Do you accept that position that the Bar Council and the CBA have taken, or do you think they're wrong?
Brian, we asked Brian to do a very serious piece of work. He was supported by a panel. Some of that work involved modelling in other common law jurisdictions which were comparable in terms of the changes that were made. You will know also that the department publishes a lot of data. This is the department that publishes a lot of data. Recent court and prison protections were published on the 4th of December. And as I've said, I totally understand that in order to get any legislation through, it's important that Parliament is able to do the proper scrutiny, and so I want to make sure that those impact statements are sound and are thorough, and that parliamentarians are able to do their work both in this place and the other place.
There are currently in the region of 17,500 prisoners on remand in this country. Will these reforms apply retrospectively?
No.
You've also acknowledged that the proposals will not make a difference to the existing backlog in the short term. Given that that is the case, can you explain to victims, to witnesses, to defendants who are currently awaiting trial, often years in the future, why you're not looking at measures that will affect the backlog in a more expedient manner?
Oh, no, that's a misunderstanding. What I've said is that legislation takes time, and so the proposals that we have accepted that we're making in relation to Sir Brian's recommendations will, of course, can only come into effect at royal assent. But we are getting on with investing in sitting days. That is happening now, and I've increased those sitting days. When the Lord Chancellor was here last year, we were talking at 106 sitting days. I'm able, record funding now, 111,250 sitting days, over 5,000 more than the previous government funded. So sitting days are up, the investment is up. Investing in court maintenance is essential and is happening. Modernisation is key, and part of that modernisation will emanate from Brian's part 2, which we can get on with from the spring of next year. So that will be happening.
So Brian's report actually envisaged trials taking place with a jury and magistrates, not judges sitting. Sorry, a judge and magistrates, not judges sitting alone. How does the government reconcile that distinction with the current proposals that are being put forward?
I think Brian recognised that we might come to a different judgment, and the judgment I came to was we are giving our magistrates more power in the magistrates' court in terms of their sentencing up to 18 months, but they could go to, or the government has the power to take that to 24. I'm recruiting more magistrates at this time, and therefore on reflecting other systems, particularly the system in Canada, I settled on the single judge.
Does it not mean that the evidence base which Sir Brian has reached was based upon his hypothesis of a judge and magistrates and not on a judge sitting alone, and therefore to extrapolate that would be a false result?
That's why the honourable member rightly expects the modelling and the impact assessment in relation to the bill that we've actually come forward with, and that will be available to the committee.
That opens the question that modelling hasn't been done to date, and therefore this is a proposal that is...
It opens the question that, as I said, that the government is doing that modelling. Some of that modelling is based on where we end up with sitting days and the concordat with the Lady Chief Justice. That will be available at the point at which we publish a bill in the spring. But I will seek to do what I can in relation to this committee before that, if I can. That's the undertaking I've given.
But it is a case that the modelling is not complete at this stage, and therefore it's based on assumptions that...
Modelling is ongoing.
Do you accept that even if Sir Brian's analysis is correct and that it will lead to a 20% reduction in trial length, that would only apply to a fraction, about 3% of trials in total?
Yes.
The other issue, of course, since you've touched upon, Lord Chancellor, is the presence of advocates and having enough people going into the criminal bar. Now, we know that junior barristers don't go into the criminal bar because it pays well. They go into it because they have a passion for criminal law. Now, part of that, of course, is the thrill, if I can put it that way, of being a jury advocate. By removing those opportunities, are you concerned that will reduce the number of individuals who will choose to go to the criminal bar when they could have a much more profitable career, perhaps in the Chancery or other areas of law?
Well, it's precisely because I'm worried about the pattern and what we're seeing with the criminal bar and indeed with criminal solicitors that I've made the investment that I have in those match-funded mini pupilages, so that we see the next generation of criminal barristers coming through. That's hugely important over this next time. And so obviously there has been some attention on changes to jury trial, but I don't think we should lose the significant investment that we're making in legal aid, the uplift in fees, and the mini pupillage scheme, match-funded scheme, to ensure that we have that next generation of lawyers coming through. I think part of your question is also, is there some disincentive almost to become a criminal barrister? Just to emphasise that trials are running longer, trials are more complex, there will be a significant number of jury trials and indeed patterns in terms of more serious cases would suggest that there will still be a lot of jury trials. So there will be quite enough work to go around.
Has your department undertaken any analysis of the impact that changes to the jury system will have on retention, particularly at the junior end of the bar?
Sorry?
Has your department done any analysis as to the impact of the proposed changes to jury trial retention of the junior end of the bar?
Both the analysis that the Criminal Bar Association has done, the Bar Council have done, and the department has done on workforce informs the decisions that we've been made about many pupilages precisely to deal with some of the retention issues. And I should just say that following our reforms, it's still the case that around 3/4 of trials in the Crown Court will continue to be heard by a jury.
That's a slightly different answer. That's about the wider retention issue of the criminal bar. I'm asking specifically about your proposed changes to jury trials. Have you done any analysis on that?
And as I've indicated, of course we've done analysis. That is why we are putting money from taxpayers into a match-funded system to increase the number of junior barristers. Of course, what sits behind that is analysis and trends that we're seeing in the criminal bar.
Grateful, Chair.
I'm going to be Vicky Slade, but just clarify, if you would answer one point. Is it a quarter or is it a half of jury trials? Because I asked a question of the Prime Minister yesterday at Liaison Committee. He said a quarter, and you just said a quarter. Your letter to me from last night says that of the 3% currently subject to trial, 0.5% will be in the Crown Court Bench Division, 1% will be in magistrates, and 1.5% will continue as juries. So that's half. And that's the answer that one of your junior ministers, Jake Richards, also gave to the Human Rights Committee, because I'm sitting on it last week. So is it a half or is it a quarter of jury trials that will be dealt with in other ways?
Sorry, I'm confused as to...
We've got 3%, I think we're all agreed on the 3% figure.
Yes.
3%
Yes.
Of criminal trials now are conducted in front of a jury. Is that going to go down to by 0.75% or by 1.5%?
1.5%.
By 1.5%. So about half of those trials.
Yes, about half.
Okay, all right. Thank you. Vicky, sorry.
Thank you, Chair. Some of this is going to be a little bit repetitive, but I think it's really important to really try and get to the bottom of it, because I'm slightly confused by some of the answers that you've given. The first one, I want to go back to Sir Brian Levison's recommendations. I met this morning, as I mentioned in questions earlier, I met the Law Society today, and they are deeply concerned, and what they've said is that the Levison proposals were an uncomfortable compromise but were understandable given the challenges. Going beyond the Levison recommendations is not acceptable as far as they are concerned, and the main reason being the retention of an element of lay participation in determining guilt. Where I'm slightly muddled is that earlier on you said you would be doing this anyway if there wasn't a backlog, which suggests that that's a matter of principle, whereas you've also said, well, there's the backlog, there's a pattern of behaviour, there's underinvestment. So I'm not quite sure whether it's your personal principle that we should reduce by half the number of jury trials, or whether it's circumstance. And so I wonder if you could just give me a bit more of an understanding on that, because I'm deeply worried that if the Law Society and the Bar Council and others and the majority of the public are uncomfortable, why there are so many people uncomfortable with this, but you seem very convinced that this is the right thing to do?
Well, let's step back, Ms Slade, because I have been in Parliament when you have quite rightly asked very strong questions about victims. And so far in this committee, victims have not been mentioned. And we are making these changes so that women who've been raped do not have to wait 3 years, that a young woman who's raped at 16 does not have to wait until she's in the second year of her university for a trial to come forward. That is what I keep in my mind's eye. And you will recognise that, of course, it is my job and the government's job to hold, yes, the legal profession, but to hold victims at the same time, and to look at the entire system, and that is the responsibility of the government, and I see you nodding your head. So we can hold at one moment the recommendations that Sir Brian's made, and we've reflected on those recommendations over many months, and then come forward in the last few weeks with our plans, and there we will get to a bill and legislation. And I've said that I do not say that Sir Brian's recommendations are, in of its entirety, the whole story, because sitting days, quite rightly, is important, and modernisation within our courts and investment. So I hold that at the same time. But I've also said to you, as a government, when we look at this system and the criminal justice system, when there has not been substantial reform since 1971 to effectively the jury system that we had, when we reflect on the patterns in crime, arrests up, serious violent crime, technology driving historic offences, more arrests, trials that go on for longer, and the patterns, that I do believe that reform would have been necessary. So I don't think this is an either or. I think you can hold both of those two things at the same time.
I just reference something else that was talked about with the lawyers. I know my colleague was talking about the bar, but you referenced defence lawyers. The Law Society told me today that they had an event where they introduced 120 new lawyers, of which just one was going to be a criminal lawyer. Doesn't matter how many rights the government takes away from people to have a jury trial, if there aren't enough lawyers and there aren't enough courts and there aren't enough legal advisors in the magistrates' courts, justice isn't going to be done, and that victim is still going to have to wait. Those other things cost a lot of money. So what are you doing to influence your colleagues in the Treasury to properly fund justice, because it has been underfunded, as you've said yourself, for many, many years? And I don't think it's just the last 14 years, I think it's been decades.
Miss Slade, you make my case for me. Thank you. Because you're absolutely right, and that's why I said this is like an operation. You do need the barristers, you do need the solicitors, and that's why I announced funding of 34 million a year for criminal legal aid advocates. That's why I've match funded the criminal barrister pupilages, as I've said. That's why court maintenance funding is 120 million last year and rising to 148 million this year. But clearly maintenance does take time and won't happen overnight. All of that ecology has to come together effectively to have a trial, and all of it requires investment, modernisation and reform. Those are the three things underpinning what I'm trying to convey to the committee.
And do you think that the money you're putting in is sufficient to make enough of a nudge to have the real impact in the backlog? Because if they're all, incremental tiny changes, what an assessment has been done about how much change the collective will actually have?
I want to see the backlog, the waiting list, coming down towards the end of this Parliament by the next election. I want to see the trend downwards. That is what we are trying to achieve, and that is my ambition.
One more question, if that's okay, which is the third time I've asked you this, so you probably know exactly what I'm going to talk about, and that is magistrates and the magistrates' court. The question was asked earlier on this morning, but I'm not sure that we got a particularly robust answer, and it may be that you might need to come back on it, and that is the impact on both magistrates being comfortable with taking cases that have potentially much longer sentences. I mean, I said this morning that 18 months ago we were at 6 months, sentencing for magistrates. By the time we get to the end of next year, they could be looking at cases with a 2-year sentence. That's a very, very big difference for somebody without legal training and somebody who is effectively a member of the community, which I value, having magistrates working in the system. But taking a decision to deprive someone of their liberty for 2 years is very different than putting a fine on or a very short sentence. What assessment has been done on the impact of magistrates to be able to cope with that, magistrates to be able to manage that, manage much longer trials, because as you said, the Crown Court trials are a lot longer, but also the the willingness of people to become magistrates and stay magistrates, given that the role is completely different, and given that they are effectively the sort of, I don't know, the school governors, if you like, of the system, but might feel that this is too much of an overreach?
Magistrates Association are supporting these reforms and are up to it, but they're not doing that in a way that says they're not requiring the training and the investment that goes in. And just as magistrates were trained to move from 6 months to 1 year, of course over this next period, and we've got some time because this, it will take us to the end of the year to get royal assent and then implementation in 2027, to train up our magistrates to take on these new responsibilities. At the moment, magistrates completed around 1.4 million criminal cases last year. That is a substantial amount. I thank our magistrates hugely for the work that they do, and I am going to be increasing the investment into our magistracy, and I want to see increased recruitment into our magistracy. My sense is that people are up for being a magistrate. They are a very important part of our system, the lay role that they take. And my view is that they can do more. They are up for more. They can make these decisions. They do the job very, very well indeed. And I want to support them to do more.
Russell and then Tony Vaughan.
Thank you. Lord Chancellor, you have spoken strongly about the importance of centring victims in this discussion, which I entirely agree with. At the moment, the average wait from reporting a rape to the end of a criminal trial is 6 years. What figure do you think would be acceptable for that period of time?
Woman waiting 6 years is our country and our state being in breach, frankly, of that Magna Carta Article 40 edict that justice delayed is justice denied. I've said that I want to see the backlog falling downwards by the end of the next Parliament. That's as ambitious as I believe I'm able to be, and I urge the committee to reflect hard on what I'm saying and what Sir Brian Leveson has said, which is that we will need reform as well as investment, as well as dealing with the efficiencies if we're serious about that. If we curtail that reform, we will not have that effect. And so we will do, as I've said, as we've been discussing about the modelling, we will come forward with that modelling and the impact during the passage of the bill. But I want to get that 6 years down, of course I do.
Lord Chancellor, please may I reiterate my question? What do you consider, in a civilised society, in the 7th richest country on earth, would be an acceptable waiting time?
Well, I would hope that no woman is waiting much longer than 2 years to get justice. That's what would feel, I think, acceptable in a complex system and in a major democracy such as ours. But we are a significant way from that at this point.
In terms of the targets that you are setting, when do you anticipate that we would reach that?
The only undertaking I can give to the committee, and I'm sorry that I'm not able to give a bigger undertaking than that, is the only undertaking I can do is that the backlog will be falling by the end of the next Parliament. But she will understand. She has heard. You have, Miss Russell. You've heard questions from this committee that might limit those reforms, and therefore the desire that I know you hold sincerely to reduce that wait for the victim, I don't believe the system would produce if we were just dealing with efficiencies. And so that's my hesitation.
I quite agree that the system will not produce that improvement if we are just dealing with efficiencies. I also question whether the proposed reforms would even touch the sides of moving that dial down from 6 years. I think the ambition is to see this start to come down a bit. So,
well, I want to emphasise, I do think it's important to emphasise that if we take this new CCBD division of the Crown Court, and they are dealing with, say, possession of a Class B drug, they are dealing with shoplifting, they are dealing with the ownership of a dangerous dog type case, they are dealing with those cases by a single judge. And Sir Brian's estimate that means the system would be 20% faster, then effectively, once you've taken those cases out, the rape case that goes to trial is speeded up. And that is the significance of the proposal.
The proposal reduces half of 3%. Jean, I'm sure it will. I think it will significantly increase the speed of those trials, but we're talking about half of 3% of the total criminal backlog. So my question is, if we want to really move the dial on that 6 years, what do we need to do, and are we going to do it?
No, I'm confident that if we're increasing sitting days to the end of this Parliament, and it's my intention to do that, if we are increasing investment in our courts and in our maintenance, and I hope to continue to do that, if we are implementing these reforms, that after the next election, we will be into a much better horizon for victims right across the board.
Thank you, Chair. Thank you for your answer so far, Lord Chancellor. I just want to come back to this issue of the impact assessment and the 20%. So what I wanted to ask about is just will it transparently show not just the assumptions, as you said in response to your question from Dr. Shastri-Hurst, but also the evidence and the analysis underpinning that figure? And in particular, will it list all of the factors which it is said would save time, so jury empanelment and deliberations, and also list those things which would add time, so things like the judge having to write their judgment, which they don't currently have to do in a criminal case, so that we can get a sense of what really underpins it?
Yes, it will.
And so, in terms of the impact assessment, I mean, how much will it show? How much of the backlog reduction will come from restricting jury trial as opposed to other measures like increased sitting days?
We will endeavour to do that.
Will it show the sitting days that are saved as a result of restricting jury trials in sitting days?
We will endeavour to do that.
Brilliant. I just want to ask about the Concord Act, which you touched on earlier. Your letter said that we may need 139,000 sitting days by 2030 to meet demand. Is the barrier to sitting 139 days physical, that is not enough courtrooms or judges, or financial? And if you had the money, could you actually physically sit those days?
We haven't got the judges, the courts, the barristers to sit to that. Obviously, that is an estimate of where we would be if we did nothing. But the system could actually not be that hot at this time.
And in terms of what the 1% of cases that is being retained by the Magistrates' Court, it's particularly important that you have a right of appeal that is effective. I just wanted to ask about the legal aid position and whether there would be any resource uplift from the legal aid agency to fund the proposed appeals, because as a lawyer I know that reading through a transcript, applying the law to the facts, drafting the grounds of appeal all takes time, and I just wondered whether the LAA will be providing funding for that.
Well, as we're introducing a new permission stage, of course I will look at the legal aid available to make sure that people are properly represented.
And I just wanted to ask about the proportion of resources. It may be that it's in the papers and I haven't picked it up, but I mean, what proportion of the total criminal court's budget is used up by the 1.5% of cases that will lose jury trial in actual money terms? Because I know we've talked about numbers of cases, and some people have said, well, obviously it's a small number to justify such a drastic reform, but what does that look like in actual pounds, and how could any savings be redeployed to cut the backlog in other ways?
Can I come back to you on that? I haven't got that figure available to you.
And the last thing I wanted to ask about is diversity, and that's something that
Yes.
I don't need to lecture you on. What specific mechanisms will there be to monitor disproportionate impacts on minority groups, conviction rates, sentence lengths, all disaggregated by race and other protected characteristics, so we can see the impact of these changes on all criminal trials, so that we can make sure there is no the problems that you identified in your report around racial bias in the justice system are not magnified, because you know very well that the conviction rates at magistrates' court level are quite a bit higher than those before jury.
Well, thank you, Mr. Vaughan, for asking that question, and can I be crystal clear that there will be, in the event of implementation, the undertaking and the commitment to ensure that all data is published, so that the full scrutiny of the effect of these changes in relation to different ethnic groups is fully understood. I would want to emphasise that centering victims means it is important that we recognise that if you're black, for example, you're 13 times more likely to be a victim of crime than if you're white. 43% more likely, by the way, if you come from a mixed ethnic background. And if you're black, you're 4 times more likely to be a victim of homicide compared to white victims. For all of those reasons, as Ms. Russell was indicating, it's important that we recognise that black, Asian and minority ethnic people are also victims and want to see the system speeding up. If your son has sadly been murdered following a knife crime, you don't want to wait 3 years, 4 years for that trial to come on. But it's also the case that the work that I did in the Lammy review on disproportionality is of course important. It did underpin our understanding of the jury system, and I did focus a lot on accountability and, if you like, sunlight being the best disinfectant. And in relation to that, it's important to recognise that judges now will be given their reasoning, that we are putting in place the transcripts and the transcribe system, because we've got the digital technology that we did not see in the Lammy review, that our magistrates' courts will now have recordings. You will know what the magistrate said, so that you can appeal it if you ever find yourself back at the bar. So for all of those reasons, accountability and transparency was the underpinning of understanding how things are disproportional, and as I say, sunlight being the best disinfectant.
Thank you. And the last question I had kind of builds on that, and it relates to the judiciary, because obviously it's not just about magistrates' court here, and a slightly kind of related issue, but as we know, the High Court judiciary is not representative of the British population, and I just wondered what, if any, additional pressure you can bring to bear on the judiciary to make sure it's fit for the 21st century, so that we have a greater reflection of British people within our High Courts.
We have got greater representation of ethnic minority amongst our magistrates since I did my review, 31% in London. We have got greater representation amongst our court judges, up from 6% to 11% since I did my review, and 21% amongst new entrants into the judiciary, which is a trend that is good, if you like, into the middle ranks and upwards in the years ahead. It is important to emphasise this because some people have not fully understood my review. When I was commissioned to do the review, I was asked to look at whether juries were fair because some people had concerns that if you had an all-white jury, it was unfair. I asked Professor Cheryl-Thomas to look at this, and she concluded that juries are fair precisely because the 12 people, whatever their background, makes the system very fair and accountable. We did not find that there was disparity between judges, magistrates and a jury, however. Some people have then gone on to conclude that. That is not what we found. There was some evidence at the sentencing point, but who recognises that judges sentence after the jury trial anyway. So I just want to make that clear to the system.
Thank you.
We're going to move on to another topic, just before we leave juries entirely. But you in your last answer there, do you accept that a judge sitting alone without magistrates, which, as you say, there is diversity amongst magistrates, a judge sitting alone is no less likely to discriminate than a judge sitting with a jury? Is that your evidence?
No, what I'm suggesting is that in the Lammy review, I looked at juries and gave them a clean bill of health. I looked at sentencing, and I did find disproportionality at the point of sentencing. I did not find disproportionality between a magistrate and a jury. That is different in terms of determination.
You're not worried at all about a judge sitting on their own without magistrates or a jury sentencing to somebody to 3 years, or possibly more?
In balancing victims of crime, and I've given you the statistics affecting black, Asian and minority ethnic people, and balancing the sorts of crimes that will be in front of the Crown Court Bench division and more serious crimes, I've come out at that 18 to 3 year threshold. That's where I've come out, and I do believe that that's the right balance. The data will all be available to scrutinise. The decision making of our judiciary will be available to. In the end, you don't have a decision or much of a decision from a judge at the moment. You will have that decision as a result of the system that we are introducing, and I think that will allow to better accountability.
You accept that the higher ranks of judiciary, I think we have no one from an ethnic minority in the Supreme Court. This is a matter we discussed with the Lady Chief Justice 2 or 3 weeks ago. One, Lord Justice Singh, I think, in the Court of Appeal, and there is no other person from an ethnic minority.
I do accept, of course, that as you go up the system, there is work to do, and that is where we will be appointing a new chair of the Judicial Appointments Commission in the coming months, and that is still a job in hand, absolutely. But of course, I know that the chair will understand that the reforms that we are making do not pertain to the very highest courts in the land.
If I could sum up that part of the session, I think we would probably say the jury's out, and we are looking forward to having a lot more data to see what the effect will be, both on jury trials and on the backlog. But the one area we haven't covered is what the effect will be on the prison population. And are you going to publish data on that as well? We know what the court review says, or the sentencing bill says, in relation to accommodating, if I could put it that way, a growing prison population. If, as seems inevitable, the consequences of Leveson are more people going to prison, because you have magistrates sentencing up to 24 months, and you have swift justice, which presumably means people are going to get custodial sentences more quickly, then prisons are going to be overflowing again, aren't they?
I don't think that's quite axiomatic, because that suggests that there'll be a different rate of conviction, and I'd want to maintain that our criminal justice system is fair fundamentally, or it's not much of a criminal justice system. So I'm afraid I can't concede that somehow there'll be a higher conviction rate because you've changed jurisdiction. What we've been focused on is the swift nature of that justice. But as I've said, of course, the modelling that sits behind it will be available to the committee.
Well, it's not. I don't ask you to take responsibility for the last government, but it was an administrative rather than political decision. The then Justice Minister decided, or then Courts Minister decided, not to increase magistrates' court sentencing powers because they negatively impacted short-term prison pressures. It's just a matter of fact, isn't it?
Well, we will be publishing the prison capacity modelling in January, and as I say, there will be modelling attached to this implementation.
Have you changed topic?
Thank you.
Sarah Russell is going to ask about civil justice.
So what area were we moving on to?
Civil justice. So we have a question about the county court, if I may. So our recent inquiry into the county courts revealed a dysfunctional system, full of delay, and recommended a root and branch review. Given that government has seen fit to commission major reviews on sentencing in the criminal court, the recommendations that we made for the county court have been rejected. What is the plan for civil justice?
Well, I've been in conversation, of course, with the Master of the Rolls. I'm not sure the judiciary are supportive of a further review, precisely because there's a lot going on in the Crown Court system at this time. But you're absolutely right. Our civil courts are an important cornerstone of our system, and certainly access to justice for many people, but also the underpinning of the 47 billion that legal services contributed to the rule of law and to this economy. I am keen to see further digitisation of our county courts particularly, which are one of the engines of small business so that people can properly deal with their disputes in a quick and speedy way. And I am keen to move forward with modernisation, simplification, and some of the progress that we've made on small claims particularly. It's also the case that, of course, in the family area, the pathfinder in the private law area is incredibly important, and I want to continue to support that and to support mediation as well.
You referred to family law, and in your introduction you said that you were proud of the increases in legal aid rates. The current fixed fees in family legal aid are based on an hourly rate of £44 per hour. If we contrast that with national rates recommended by HMRC for solicitors in general, solicitors with over 8 years' experience, the recommended rate is £288 per hour. This excludes London, so this is national rates. Solicitors with over 4 years' experience, £242 an hour. So that's anyone who's basically sufficiently senior to do any sort of supervisory work at all whatsoever. Any newly qualified solicitor up to 4 years, £197 an hour. I would reiterate the current legal aid rates are based on £44 an hour. They went up £1 an hour in 1996 and haven't been reviewed since. Discuss.
Well, in looking at the balance, and I know that Sarah Sackman has, Minister Sackman has been on this issue very deliberatively, the evidence base was that we did need to come forward with making progress on housing and immigration first, and of course we are funding the Pathfinder project, and there are other ways of resolution, particularly in the family arena, mediation being one of those. But I do want to emphasise that just as we have seen in the criminal area, solicitors and barristers moving to other areas of work, that I have been concerned at those patterns in family law, and I hope to be able to come forward with further proposals in the months ahead.
Lord Chancellor, the only people who can get family legal aid have suffered from domestic abuse or their children are being taken into care. I would strongly suggest that mediation is probably not appropriate in most of those situations. £44 an hour is completely and utterly unsustainable. The same position applies in discrimination employment work, where recently there was a tendering exercise. The HMRC were looking for 4 potential providers of discrimination work. They received 2 tenders. The system is literally collapsed.
I don't want to diminish the challenge. We have launched a new survey of legal aid providers to understand fully the context, and we are commissioning a feasibility study on the best way to monitor demand for civil legal aid particularly. There was acute areas in the area of immigration and housing, which is why we prioritise those areas, but I do not want to diminish the seriousness facing those who've got family disputes.
Move on to the employment tribunal system. There are now over 500,000 open claims. Individual unresolved claims are up 33%. New claims in are up 33% in quarter 2. Claims resolved are down 10% in quarter 2. We are obviously producing significant new employment legislation, which of course as a Labour MP I support hugely. Nonetheless, it is very, very stressful for both businesses and individuals bringing those claims, when those claims then are sat within the employment tribunal system for years on end. And it is now years on end, typically. What is the plan to deal with the increased caseload that will inevitably follow?
Well, the story that I told of austerity is real, and I know that, Ms Russell, you recognise that. We do have to prioritise 18 months into government. I do recognise the huge challenges in our tribunal system, particularly the employment and immigration tribunals. and they do require investment. But in the spending envelope I've sort of set out where I've had to put the priorities, and my priorities is to see the backlog in the criminal arena coming down, and to support legal aid in the areas that I've outlined. But I do reckon, I have been able to support employment, and she will recognise I made a decision. There was a suggestion of fees, which I was very keen to act to stop in the early weeks in this job. But I do recognise there remain challenges in the Employment Tribunal.
And lastly, on the subject of SEN tribunals, again, 25,000 cases were registered last year, but only 20,000 were disposed of. The cases in question are obviously children who have education, health and care plans. These have typically taken a long time to come forward in the first place. Children are waiting long periods of time for diagnosis. They're then waiting long periods of time for an agreed EHCP, and then if they're not agreed, they're then waiting upwards of a year now for a tribunal date for these children who are exceptionally vulnerable and often out of education. Given that 99% of those appeals are successful, what do you propose for that system?
Well, you will know, Ms Russell, that the Secretary of State for Education is coming forward next year with further proposals in relation to send young people, and so we're working in lockstep with her. And in relation to that, and indeed the previous question around employment, I am pleased that the department has got itself into a place where it does require other departments where they are making changes to have a justice impact assessment, and that therefore our tribunals are properly compensated to deal with any extra work that flows as a result with that. So we're in good discussion with the Department of Education, and as those proposals come forward, we'll be able to see the impact for SEND cases.
Before we move on to prisons and we move off courts, you had a question?
Yes, thank you, Lord Chancellor. If I can ask a question quickly, following on from the question that was raised by the MP for Congleton, who mentioned the 6-year wait that women rape victims face. The charity Rape Crisis prepared a report last month, further to a previous report that they had prepared back in 2023, where they've said that the backlog of sexual offences cases in the Crown Court, 17% of the backlog is of sexual offence cases, and that's an increase from 9% in 2019. And the Ministry of Justice data itself shows that there are 13,238 sexual offence cases awaiting trial, an increase of 66% from the previous Rape Crisis report in 2023. So we have many sexual offence cases that are just not being tried. Now, the Rape Crisis and also the Law Commission have said that we should have a specialist sexual offences court. Do you agree with that? Is that something that you are thinking of implementing?
Well, at this time, the changes that we're making are precisely to ensure that for those very serious cases that they come on more quickly. Now that is as true of murder cases or child sexual offences as it is of rape. All of those cases we want to come on more quickly, and that's why the 20% reduction that Sir Brian estimates as a result of stopping the right to elect, changing mode of trial, giving our magistrates, where there isn't the significant backlog, increased sentencing power, and the new Crown Court Bench Division will bring about that change. We're not proposing at this time a new jurisdiction solely for sexual offences.
Leave it there. Thank you.
Thank you. Lord Chancellor, I'd like to ask you about prisoners released in error. On the 2nd of December, you announced that 12 prisoners had been released in error since your statement on the 11th of November, with 2 prisoners still at large. Is that still accurate?
Well, I first gave figures on the 11th of November at my oral statement. At the time, I announced for the first time an ad hoc data release from April to October of this year, which showed that there had been 91 releases in error in that period, and I confirmed that there were 3 unlawfully at large. You're right that I gave figures again on the 2nd of December during a media interview. At the time, the numbers were 12 releases in error since the oral statement and 2 unlawfully at large. That is more data released out of the cycle. The last government, as you know, were releasing once a year in July than ever before. In the meantime, and importantly, I've met with Dame Lynn Owens just yesterday. She's looking closely at the data issue. She's due to report in the new year, and she will be making recommendations into data releases and that data. And it's important that I allow her to do that work. And so there will not be further data releases until she comes forward with her report in the early part of next year.
But it would be reasonable for me to assume that that figure is no longer accurate and there have been more accidental releases since then.
Well, between April 2024 and March 2025, there were 262 releases in error. That was averaging at 21 a month. In the 7 months from April to October, there were 91, that averaging at 13 a month. I did indicate that the trend looks to be downwards, and Mr. Fox, you will be aware that I did put in mandatory stronger checks that I wanted prison governors to make, a new investment in tech and digital, because this is a paper-based system. It has been a paper-based system for many years. The last government had 4 different release schemes that added to complexity. We came in as a result of the prison capacity crisis, which this committee has looked at very closely. We introduced the SDS40 scheme. That is a lot of paper complexity, and therefore there are errors, and it was important for me to put in that new tech, to have a courts hotline, because there are problems between the courts and the prisons sometime in this area, and of course Dame Lynn Owens' review. So I think that has made some contribution, but this is an uphill task, partly because it's a paper-based system, and partly because we're asking very junior prison officers to make this decision. And Mr. Fox, you will be aware that under the last government we lost 6,000 prison officers up to 2013. Those officers who were very experienced, never to come back, have gone out of the system. And for all of those reasons, errors are being made. We're asking good people, prison officers, to work in a pretty pressured environment. And I should say that it's important to recognise, notwithstanding the errors that have been made, that there were 57,000 releases from our prisons, and these errors account for 0.5%. Now, for all victims, that is worrying, and the system should not be making these errors. But I do want to put those errors into context.
You talked about a paper-based system and how it was very complex. But given that the number of prisoners released by accident doubled between 23-24 and 2024-25, would you accept that your government's early release schemes made the system even more complex and more unmanageable, and that is partially responsible for the number of prisoners released in error?
Well, there were 800 releases in error under the last government.
In which year was that?
There was very serious. The figure was spiking from 2021. As I have said to you...
262 was an all-time high.
Let me, as I have said to you, that there were 4 different release schemes in the last stage of the last government, which added to complexity. And we put in an early release scheme that has also added to complexity. But that scheme was put in to make sure that we still had the prison places to lock up very bad people, and I don't think, Mr. Fox, you're suggesting that we should not have done that, because you, I know, will be someone who wants to see criminals in the right place, and that's in prison. So yes, the truth is that our officers are dealing with a complex paper-based system. That is what we inherited. That is what we are unpicking. And just to remind you that under the last government, Rayon Nubi released in error, Louis Mutasavis released in error, William Fernandez released in error, and William Fernandez, who was released in error in March 2021, went on to commit horrific sexual crimes. That is to say that these errors have been happening under both governments. We need to bear down on it. We need to see that number coming down to historic levels. But I actually don't believe this to be a partisan issue. I believe this to be an issue that is occurring because of complexity, because of paper, and because junior people, both in our courts and in our prisons, are having to make fine assessments in a prison system that actually releases many people every year.
Lord Chancellor, you referred to the last government being responsible for 800 prisoner releases. I assume you're talking of the cumulative over 14 years. In the year you referred to, 2021, 54 prisoners were released in error, and I'm taking these numbers from your webpage. In 2023-24, it was 115, and that figure doubled to 262 in 24-25. That's a massive increase. It's 5 times more than 21-22. And I'm putting to you that actually it's the very complicated release scheme that your government put in place that is responsible for that spike.
Well, within the figures that you've just suggested, there was a spike from just over 50 to 121 under the last government. So Mr. Fox, you do accept that there was a spike under the last government, and I've said there were 4 prison release schemes that contributed to that. We're in agreement. I've also said that the SDS scheme that we introduced when we came into government because of an emergency that I think he accepts, so we had to do it, has also led to that complexity. So I don't think there's actually disagreement between us.
You said last month that you'd introduced the strongest release checks that have ever been in place for prisoners, and these included mandatory checklist and the physical presence of the governor for certain releases. Why have there been subsequent mistaken releases since then, and where does responsibility lie for those mistaken releases?
Well, I've said that you can never, ever, as a Secretary of State, rule out human error. I've said that there are 57,000 releases from prisons every day. A prison's not like a warehouse. There are people that come in and out, some people leaving for day release and employment and coming back to prison. Some people releasing to go to hospital and coming back to prison. Some people being released to go to an immigration tribunal and coming back to prison. And some people that are released permanently, either into probation or to an immigration centre for removal. So that's a pretty complex ecology that we have. Within that, this is a paper-based system. And so I have also said very clearly that there is a mountain to climb. I have put in place mandatory and stronger checks. I have put in place new investment in tech, and I have put in place a courts hotline because of the errors that were occurring on assessments of warrants between courts and between prisons. I did that as an emergency set of things to try and bear down and grip the system. But the important work that underpins that is the independent review that's being led by Dame Lynn Owens. She will report in a few weeks' time, and the government will act, of course, on her report. But there is a mountain to climb to get these figures down to historic levels. And those are historic levels that preceded both the spike that we saw under the last government and the spike that we've seen under this one.
When Kabatu was released in error, the Ministry of Justice published his photograph, his name, and his offence, which was just as well because it was actually a member of the public who located him and phoned the police. Can I ask, why don't you do this for all releases in error?
That must be an operational decision for the police. It is for the police to make assessments of risk, not for ministers to make that assessment. That is for the broader criminal justice system. And so it is the case that sometimes the police are keen to release information to the public that will help to apprehend someone who is at large, particularly someone who might be of risk to the public. But it is sometimes the case that people are not at risk to the public, or indeed the police are able to apprehend someone, and indeed publishing their name and might mean that they go underground. That must be an operational decision for the police, not for ministers.
You say it's an operational decision for the police, but in the case of Kabatu, I understand your department didn't even tell the police for 7 days that he was on the run. And I put it to you, Minister, that actually it's just too embarrassing for your department because so many prisoners are released by mistake.
I've said to you in terms that must be an operational decision for the police, and of course the Ministry of Justice is liaising with the police on a daily basis on a range of things. We work as a whole criminal justice system. Just last week I was at the Criminal Justice Board, and that brings together the police, prosecutors, Ministry of Justice, probation, the entire system it brings together. It's a whole ecology across the criminal justice system. That is the seriousness that actually underpins what we're talking about when we talk about the criminal justice position. And I'm sure, Mr. Fox, you understand that it must be for the police to make those judgments.
Thank you, Chair.
Thank you very much. I think now we're going to move on to Pam Cox.
Thank you very much. Lord Chancellor, this committee has been very concerned over the past year to ensure that both the prison and probation services have a robust and well-supported workforce, and we've just been alluding to the challenges there. We've been monitoring capacity challenges in both sectors, so I'd like to ask you about skilled worker visas and the impact in certainly the prison sector. How many prison officers are currently on skilled worker visa, and how many will be lost over the next 12 months as a result of proposed immigration changes?
Well, can I emphasise that I recognise that this is an issue that has preoccupied the committee, and it's an issue that's preoccupied parliamentarians. And I am in discussion with the Home Secretary on this issue, and I hope to come forward with proposals shortly, and I'll update the committee as soon as I'm able to do that. And I think that we have found a way through this issue. It's also the case that I want to recruit more prison officers who are local to communities all over the country, and I particularly want to be able to recruit prison officers into London and the South East, where there have been challenges because of the labour market and people being able to get jobs in other sectors that are commensurate to the sort of pay you get for being a prison officer. I will update her with the latest figures because the figures move around. I'm happy to write to her to give her the latest figures, but I hope to be able to make an announcement shortly.
Thank you very much. Do your discussions with the Home Secretary and the Home Office, did they concern an exemption for prison officer roles or other matters?
I think it's a way through with the Home Secretary that's a satisfactory way through. And obviously, I wanted to reassure myself that we could recruit the amount of officers that we need in the required time locally, because that's the best situation in the time available, while recognising the important commitments that we have in relation to reducing our reliance on immigration. And that's the balance that I've sought to strike, and I think that we're just about to get there.
Thank you, and I ask partly because a recent inspection of HMP Liverpool revealed that there was significant anxiety among prison staff affected by the skilled worker visa changes. So how are you and your colleagues managing morale among those who currently hold skilled worker visas at this challenging time?
I do recognise that people currently on skilled worker visas, and they're largely from West Africa, and I'm hugely grateful to the contribution that they have made, do want a degree of certainty and understanding, and the prisons themselves, and I met with a round table of governors, certainly want certainty where they rely hugely on those extra numbers. And the most important thing, of course, is that we have prison officers able to meet the demand that we see in prison places, and that's paramount. And so that's the conversation that I've been having with the Home Secretary, understanding the desire to get a British workforce across the board. And I think that there is a way through, and as I say, I hope to be able to come back to the committee very shortly on that.
Thank you. I'll wrap another question around staffing and probation, if I may. It seemed to follow on quite nicely. So the sentencing bill places a welcome and fresh emphasis on community justice. That will, of course, place additional demands on probation services. The probation service currently has a vacancy rate of 22% nationally, rising to 33% in some regions. So given current and projected staffing shortfalls, how will probation practitioners be able to manage increased casework safely?
Hugely important that we secured 700 million going into probation over this next period so that we can recruit those extra full-time equivalent staff. It was standing at 21,527 in September of this year. That's an increase of 22% from June of 2021. It is an upward trend. There is more to do, and I know that you know our commitment to recruit 1,300 trainee probation officers over this next year. But it's not just about the numbers. It's also about helping our probation officers get back to face-to-face contact with probation officers. Can I also say that, and I deliberately made my first visit as Justice Secretary to a probation setting in Islington, and then very shortly after that I was with probation officers in Chatham. We do need to reward our probation officers better, and I am in discussions with the Treasury so we can give our probation officers a good reward, recognising too, and I know that Scott, that you recognise this, it's a profession, 76% of our probation officers are women, and often we see inequality in terms of women, in terms of pay. But the other thing that's important so they can get back to that face-to-face is digital technology, and Justice Transcribe, which they were piloting in Kent, hugely important. What those officers were saying to me is life-changing, that you can quickly, using AI, get the details down and get back to face-to-face contact, visiting people, being with people where they're at.
Thank you very much.
Slade.
Thank you. I'd like to, and it's quite an interesting link back from probation, because I want to look at the other end, and that's remand. He sighs.
I don't sigh. I think it's very important, and it's
it is
a tricky issue at the moment.
It is a really tricky issue, and the data on it is absolutely staggering. That 20% of the prison population is somebody that's on remand. So that's people who've not been convicted, who may be innocent. I admit a lot of them won't be, and it's important that, you know, where people are convicted of violent offences, or where there are, you know, people who are afraid of their perpetrators, that they are kept out of the way. So I would hate you to pivot to that position, but there are some people here who are going to be serving longer on remand than they would do for a sentence. We know when this committee, prior to many of us being here, looked at this last time, there were over 770 who'd done more than 2 years. At the moment, the number of people on remand has gone up 55% in the last 4 years, and nearly 1 in 5 of them have been beyond the custody time limit. What are you doing to review, given your commitment to technology, the use of technology to allow more people to be remanded on bail, tagged, curfewed, etc., so that you can get that prison population down in a safe way?
Ms Slade, you're absolutely right. The remand figures are deeply worrying, and the spike in the wrong direction suggests a system that's overheated. At the moment we've got 17,700 prisoners, which represents a 20% of the total population, and that's up 70% since 2020. And it does mean that there are real pressures in our reception prisons, particularly. 2/3 of those are awaiting trial. A third of those are awaiting sentence. Speeding up the courts, and the lion's share of questions today has been on our court reform proposals, will be significant in relation to that remand population, of course. But also the Bail Information Service, and actually better assisting people to apply for bail, and making sure there are the right incentives to apply for bail, is also important. But you're right, using community accommodation and tagging as an alternative to remand, and legislating as we have done in the sentencing bill, so that people not likely to be punished with prison will not typically be held in prison, will make a significant shift on that remand population. So I expect to see the remand population falling as we move into 28-29.
So there's two things there. I mean, we said earlier on that it's going to take some time for these reforms to change. There are 17,500 people currently in the system. I don't get the impression that those people currently in the system are going to really benefit from those changes, because even those that are, been there for a year, within the next year they will eventually get their day in court. But how are you proposing any changes to the existing system so that you're driving forward in the same way as Leveson 2 will drive forward the other part of the system, to drive forward decisions made around bail? And then the final point I want to ask about is conditions for people who are on remand, who are in a different space mentally to people who have been convicted. They know where they are, they've got a programme. What more can you do to make sure that people who are on remand have decent access to education, mental health facilities, work, in the same way as the regular prison population? Because I'm hearing a lot about people being regularly moved and not having as good an experience as settled prisoners.
The last part of what you're saying in your question is absolutely right, that if our remand prisons like Pentonville, Wandsworth, in London are running as hot as they are, if people are moving in and out, and if you're on remand, this is not a cohort of prisoners who are up for education, employment training in the same way, precisely because they don't know how long they're going to be in the prison. So we do have to get the population downwards. The first part of your question, actually, let's not forget the sentencing bill, which is significant and should be implemented in the spring, and therefore be able to, or get royal assent, in the spring, and be implemented as we head towards Easter, and that therefore will have an immediate effect on that, or begin to have an effect, on that remand population.
Excellent.
Thank you. I've got two very specific questions and then two slightly more general ones. If I can just point out that the NAO said that the sentencing bill might actually increase electronic monitoring caseloads by between 8 and 14,000. I wondered what HMPPS's estimate of the number of additional offenders who will need a tag are. I then have some questions that relate to that, and I know that we heard from the previous Lord Chancellor that Serco's performance was below acceptable levels when we saw her at the beginning of this year. I wondered what Serco's performance was like now. And at that time we were talking about them having a problem with the supply of tags and equipment that was appropriate to those they were trying to tag, and whether that's improved and whether it's a satisfactory service that they're offering now. And then
don't want to forget your questions.
No, right. Okay, go on then. So there's the Serco thing. There's the 8 to 14,000 and what HSBPS, and then the other thing that I just wanted to ask you about on this particular matter was the tagging offenders at source in that pilot that's taking place in 6 prisons, and whether that's showing that that's going to work, and whether that can be rolled out in all prisons, and whether that's a good thing to save that gap between release and tagging.
I want to let the pilot, to study what we learn from the pilot closely, but I am interested in the benefit that you might get from tagging people from prison rather than tagging people at home. But I think it's a little too early to give an estimate of that or understanding of that from what I'm told from officials. But the indications must be that it must be a good thing to get them quite early.
Can you give me a hint as to what the bad thing about it might be?
Well, it's just how the system is working, and if it's working effectively, and if
I can't really see a good reason for not doing it like that, but then I'm me and you're you.
The benefits feel self-evident, but the whole point of having a pilot is to see if it actually works. And of course you do need staff in the right places with to do that effectively, and other things if you are moving from pilot to a national rollout when the system's quite hot as a result of the sentencing bill. There will be an increase, of course, in tagging as a result of the sentencing bill, and that sits behind your questions, and you're absolutely right about that. We do think that obviously we will see a reduction over time in reoffending. 20% reduction is what the estimates are in terms of those who are tagged by curfew, and we expect tens of thousands more criminals will be tagged and monitored over the next 3 years, particularly as a result of the changes that we're making. Minister Timpson has had numerous meetings with Serco, and I am looking forward to meeting with Serco, with the Perm Sec, I think next month, now we have had to be more exacting about ensuring that they are living up to their contract, and that work continues as we head into implementation following the sentencing bill when it passes through Parliament.
And do we have a sense that actually our end of things, our procurement and our writing of contracts is up to scratch? Do we think that?
It's improved considerably from where it was.
It's got some way to go?
It's improved considerably from where it was, and we've got a roadmap as we get to implementation later on in the middle of next year.
Thank you. Thing 2. I was going to ask you about more offenders being managed within the community, and that whole matter of what steps have been taken to increase the availability of support services. And back to that electronic monitoring thing, we heard last week, we were talking about prisoner accommodation, those who are released, their accommodation. And again, the National Audit Office said the increased use of electronic monitoring would depend on prison leavers having and finding suitable accommodation. But it seems that the number of people leaving prison with somewhere to stay on the night has actually reduced in recent years. And we're very clear, aren't we, about the fact that last week's evidence showed that there wasn't enough accommodation for the number of people to meet the demand for accommodation. And I just wondered what you might be doing to address that particular matter.
Very important, because in the end we know that to reduce reoffending, there are sort of 3 key buckets that are important. One is housing, the second is employment, and the third is sort of mental health, addiction type issues that can drive offenders back into reoffending. Very pleased, and this is my first opportunity to talk about it because it's just last week, that with our colleagues in the Department for Communities and Local Government, we've now committed to a 50% reduction in the proportion of people who become homeless on their first night out of prison and are subject to probation supervision. And that is an important target to set the system. We know if you're sleeping rough on the first night, it's heading downhill effectively from there. So making a commitment to reduce that, working with local authorities, is hugely important. The second thing is also an overall increase by the end of this Parliament in the number of prison leavers in settled accommodation at 3 months after release. Again, working with local authorities and communities to ensure that there is a safe place to land for those offenders so that they can properly get on with their lives. And of course, the trajectory, and I do want to, there have been reflections on the last 14 years over the course of this committee, but there was an upward trend in terms of the employment picture for prisoners, and the proportion of prison leavers sentenced to 12 months or more who were employed within 6 months of their release more than doubled in the past 4 performance years, which is really important. And obviously I want to continue that trend and the good work that's going on to get those prisoners employment.
Can you remind me, from what to what?
The figures that I've got in front of me are that we went from 15 to 38% in 2024-25. So 15% in 2020-21 to 38% in 2024-25, which is really important. But I think there is more to do in terms of working with colleagues in health, particularly around mental health, which the numbers are quite worrying. In 2024, 61% of offenders in the community reporting with mental health, 63% in custody with an identified mental health need. So those are profound challenges.
Thank you. I can think of all sorts of questions I'd like to ask, but I might write to you instead. Can I ask you just 2 general questions now? And that is, I wondered if you could just give us an overview of your view about what should happen where you have prisoners who proclaim innocence over an extended period of time. And I'm aware of that, well, we're all aware of a number of cases where people have gone way past their original release date with no discount whatsoever, and they still say they're innocent, and they still say they're innocent. Just wondered whether you'd got any thoughts about how we deal with people who would prefer to stay in prison over an extended period of time than be released because they feel it's a matter of justice and honour that they get their appeal and are proclaimed innocent if that's what they want. Just wondered how you feel about that. What do you think we should do? We have a system, which is the CCRC. Might not fit everybody at the moment.
And I haven't heard representations on this from the CCRC, but I'm happy to hear them. I mean, having visited so many prisons over the years, I am aware of that cohort, small cohort that I think it is, Ms. Munt, that you're talking about. It's obviously difficult for the system to discern the merits or truth of the assertion. And it does feel, to some extent, a judicial assertion or a judicial assessment, or at least one that should be made by the parole board, not by the minister. So I haven't got great reflections on that, but I'm happy to hear from you if you have.
Thank you. And can I just test you on IPP sentences? Would you like to say something about those? Because I mean, they were abolished in 2012, weren't they? And we have. We've looked at this a little, have we not?
Well, I do recognise the significant issues that exist for IPP prisoners. I think we've got to support and deepen our action plan with the prisoners that are there. There's more work to do on recall. I think there's more we can do on support for those prisoners that have been in a substantial time, recognising the real challenges that exist for some of those prisoners, again, around mental health and their predisposition, really, to get into trouble, both in communities and in the criminal justice system. It's a matter that has been a topic of great discussion in the other place. during the passage of the sentencing bill, where there are obviously a cohort of senior members of the Lords and former ministers who feel very strongly about this issue precisely because it's an issue that they implemented.
Thank you very much. I'm going to go to Warinda, then Sarah, and then Pam. That may be it, or I may have 2 minutes at the end.
Lord Chancellor, when it comes to providing support services for offenders and the issue of stopping reoffending, with women offenders, over 80% of criminal justice involved women have themselves suffered abuse at some point in their lives and have either been diagnosed with a mental condition or have been referred for a mental health condition. A few weeks ago, I visited the Black Country Women's Aid Women's Centre, and I was really impressed with what I saw, because it was like a one-stop shop where women offenders could come in and get advice on housing, financial advice, health advice, and what's more significant when we're talking about probation is that probation officers actually came into the women's centre and saw the offenders, and so it was providing a very holistic approach to providing support and also with the view of stopping reoffending. So my question is, are there any plans to actually involve women's centres with rehabilitation and having a probation service? And are we going to be providing any financial support to these women's centres? Because with what I saw, I think it's a great step forward in helping women and to prevent reoffending.
In short, yes. I have met many women that are in the criminal justice system as a result of a man who's abused her, a man who's pimped her, a man who's taken advantage of her. I think there's lots more that we can do to reduce the number of women in custody and in the prison system. Minister Timpson shares my view, and we're working very hard on this. I'm aware of the Hope Project in Southampton doing great work, and when I'm up in the Midlands, I'd like to see this scheme. Women's centres are essential. I'm looking at allocations at the moment, and I don't want to jump ahead, but I hope that I can work in this area. And of course, the Women's Justice Board, really important, the work that they're doing. Thank you.
Yeah.
Approximately 12% of the total prison population is currently comprised of foreign nationals. Relatively, actually, foreign nationals are underrepresented within the prison population relative to their age profile and demographics. But so I certainly don't want to be fueling suggestions that there are sort of disproportionate problems with foreign national offending. But nonetheless, the government announced in August that we would speed up removals directly from prison of foreign national offenders. There has been an increase in foreign national offender returns, but it is a significant change if we manage to deport more people from prison immediately, and very desirable. How is that going?
Well, when we implement the sentencing bill, I think it will be very important to be able to deport these people as quickly as possible, and it will speed the system up. And I think that must be good, because I don't think that the taxpayer wants to fund them in the system. There were 10,700 foreign national offenders held in custody on the 30th of September 2025. The three top nationalities in prison were Albanian, Polish, Romanian. I was very pleased last year that we removed over 2,700 FNOs under the early removal scheme, and actually in my previous role as Foreign Secretary played a significant role in getting those returns up as well. And of course that was a massive increase, 74% increase compared in the same period back in 2023. I think it's what the public want, I think it's what the public demand, and I think as soon as we see implementation of the sentencing bill, that will all drive us in the right direction.
Sir Chris Whitty, Chief Medical Officer, has just published quite a hard-hitting report on the health of people in prison and on probation. There are three high-level recommendations. One is around the need to prioritise preventative health care for chronic conditions in prison. Another is around the sharing of health data between, for example, prison medical services and GPs and NHS. And the third is around the fact that people on probation often have very, very high health needs compared to the general population. What's your view of the report and what's happening with those recommendations?
Can I write to you, Ms Cox, to update you on that report? I will be meeting with the Secretary of State for Health in the new year to discuss that report and other things, because it is important that we just have much closer working, I think, with the health system, particularly the spike that we're seeing in mental health worries me. So can I update you in due course in the spring?
Thank you very much. Yes.
I don't think any of my colleagues are looking to ask additional questions, so I will abuse my position and ask one or two final questions, if I may. Just going back to probation, first of all, probation is having to do a lot of heavy lifting in terms of alternatives to custody, early release. The significant sum of £700 million has been mentioned, but can you say how that divides between additional probation officers or, on the one hand, additional tagging, which you were asked about earlier, on the other hand, and what confidence you have, given the very underwhelming inspectorate reports there have been into probation services recently. No fault of the officers there, but clearly the service, there is both low morale and underachievement. How do you think that service, in the current state that it's in, is going to cope with all the additional pressures which your policies are putting on them?
Well, that's why the money is so important. And it goes back to the points that I made before. The two things that probation officers say to me is pay, and we will have to settle their pay into next year when we come back in the new year, and workload. And that's where the technology is hugely important. That's where investing in further staff are important. The recruitment targets that we've set and meeting those recruitment targets are hugely important. But it's also where our vision, which we set out in our future probation service, it is hugely important. When we made that commitment to reducing workloads by 25% by 2027 is essential, because 2027 is effectively very important once the sentencing bill is implemented. But also probation reset, which is our commitment, very importantly, to ensure that our probation officers are spending more time with the most serious and dangerous offenders, and we're getting the balance right across the cohort of people that require probation in our communities, and working with them to achieve that. So there is a lot to do, but what I would say is we all know that when we look across the criminal justice system, the lowest base of all was probation, because of the botched, unbelievably bad changes that were made by Chris Grayling, which were damaging to a Rolls-Royce service. And we've got to get this service back to being a Rolls-Royce service once again. Wonderful people, hugely committed, who need a lot of support. I'm reluctant to break down the 700 million figure at this stage. Some of it will be used for recruitment, of course. Some of it will be used for our future probation service and the probation reset. So I'm reluctant to give a breakdown, because this has got to be a flexible system working with probation officers on the ground. And I met with the inspector to discuss what he's finding. There are green shoots emerging there.
We talked a lot about modelling at the beginning, and you said you'd come back to us in relation to the court's backlog or publish evidence. Don't you have a similar problem with prisons, which is, yes, you are finding alternatives to custody, yes, you are releasing people early from prison, yes, you are building new prisons, but at the same time the numbers are set to rise. Isn't it right that prisons will remain full for the foreseeable future, isn't it right that we have excessive numbers of people being returned to prison because of sometimes relatively minor breaches of the terms of their licence, and rehabilitation is going to be very difficult going forward if you still have full prisons throughout the country?
Well, it will take time. This is not going to happen overnight, and you're right about that. But I do think we will see an uplift initially after the sentencing bill. But I think that both the sentencing bill, then as we get into 2027 with the courts bill coming into effect, we will start to see the pressure take effect. I think the investment in probation officers as those new officers come on stream, which will be hugely important. The reducing workload that technology will bring will be hugely important. And of course, we get the extra prison places coming on. We've already got 2,900 extra prison places. Now, that's really significant. And we only had 500 in 14 years under the last government. Getting to 14,000 by 2031 should not be underestimated, because that, of course, increases our prison capacity. So all of that combined will make a big difference. But it took a lot of years to run this system down. I don't think anyone thinks that you can turn this around in 18 months in office. And so all of my remarks are, I'm indicating improvement over the course of this Parliament as we head into 2028-29.
Very last question. You were asked in Justice Questions this morning, although the answer came from one of your junior ministers, about the current hunger strikes that are taking place in prisons. That was replied to with a very firm no, the question about whether ministers, or I assume officials, would meet with representatives, the legal representatives of those. So I don't imagine I'll get a different answer from you, but are you concerned, given we often talk about self-harm, or we often talk about the risk to prisoners in that way, are you concerned with what's happening in relation to those hunger strikes, and what provisions are you making for the health and welfare of those prisoners?
Well,
or remand prisoners?
Every year, over 100 people do refuse food in prison and go on hunger strike. There are established rules which were set up back in 2012. Those rules are loosely referred to as the Mandela rules. They were actually updated earlier on this year, and individuals that diminish in health do go to hospital, and some of these individuals have been to hospital. They then become the responsibility of colleagues in the National Health Service, and of course the prison system works closely with the National Health Service. There have some who've suggested that I should act to give these individuals bail. The Chair will recognise that that is not something that any Secretary of State could possibly do, and it would not be right to do. That is a judicial decision that must be made by judges, and indeed lawyers are able to apply for bail for individuals, and they can go before the courts. If there are issues that require complaint or concern, those should be raised with the prison governor or raised with the prison ombudsman. But the prison system is used to dealing with people who go on hunger strike. These are sensitive issues, but I would also remind the Chair that some of the offences are very serious offences, and it's for a judge to determine whether you should be on bail or whether you should be in remand in prison, and it's judges make that determination. But they are offences of criminal damage. I think a police officer a female police officer was attacked in one of these cases, or involving a number of these defendants. So I simply say that the established system must be followed, and that must firstly be to the governor, or to make a complaint, a formal complaint. The prison ombudsman is there. It is not routine for ministers to get involved in these cases.
Thank you very much, Secretary of State. It brings an end to our proceedings for this afternoon. And it remains for me to say thank you to you and to the Permanent Secretary, who's had a sort of an easy afternoon, but a quieter afternoon since you might have imagined, and to wish you a Merry Christmas and extend that to all the members of the committee and indeed the public and press. So thank you very much, and we'll end our proceedings there. Order.